Hi, I wanted to talk about what is so-called improper influence in the California legislature. If you look at California's Constitution in Article 4, that obviously deals with the legislative branch of state government, it is a felony for any person who seeks to improperly influence the vote or official action of a California state legislator. So, Section 15 of Article 4 not only provides that the person who seeks to improperly influence a legislator, but also the legislator who is so-called so influenced is also guilty of a felony. So, what are the bases for this improper influence? Well, Section 15, again, of Article 4, provides four bases that are deemed to be improper influence. Let's go over what those are. Here is the language of Section 15 of Article 4. A person who seeks to influence the vote or action of a member of the legislature in the member's legislative capacity by 1. Bribery, 2. Promise of reward, 3. Intimidation, or 4. Other dishonest means, or a member of the legislature so influenced is guilty of a felony. So, what do these mean? Well, unfortunately, Article 4, Section 15 does not define any of these words or terms or phrases, and also California statute doesn't. So bribery is not defined in California law. One common dictionary definition is the act of offering someone money or something valuable in order to persuade them to do something for you. There's almost no case law in this provision of Section 15. However, I did find one appellate court case which held that picketing and leafleting by members of School Employees Association outside the personal business offices of two members of the governing school district board, one of whom was an attorney and the other was an accountant. This did not constitute bribery or any other corrupt practice. So basically, the court held that it was not bribery, even where picketing constituted an implicit promise that if contractual demands of picketers were satisfied, then the picketing would cease. What might constitute bribery under Section 15? I mean, I would think it would be obvious that bribery is offering money in exchange for a vote or some other official legislative action by that state legislator. What about promise of reward? It too is not defined in California law. A dictionary definition is it's someone will definitely receive a sum of money that was offered by another. So, what might constitute a promise? It would seem obvious again that a promise of a financial reward under Section 15 amounts to promising a legislator some sort of financial gain in exchange for her or his vote or other official legislative action. Now, what about intimidation? That word is also not defined in California law. One dictionary definition I found is when you frighten or threaten someone, usually in order to persuade them to do something that you want them to do. So, what might constitute intimidation under Section 15? Well, I would think it could include efforts by someone to get a legislator to vote, or even not to vote, or to take some sort of official action because that member felt threatened or frightened into doing so. How about other dishonest means? Well, not surprisingly, it's not defined in California law. One dictionary definition I found is it concerns being deceitful or untruthful. Now, these words basically mean unworthy of trust or belief. Also, dishonest implies a willful perversion of the truth in order to deceive or cheat or defraud somebody. So, what might constitute other dishonest means under Section 15? I think it might include, obviously willful or intentional efforts by someone who is being untruthful to deceive that legislator in either their voting or in conducting some other official action as a legislator. Unfortunately, as I've pointed out, there aren't reported cases interpreting Section 15 directly, so there's no clear guidance from the courts as to what constitutes one of these four improper influences. Nonetheless, if we use some common dictionary definitions and frankly our own common sense, we can expect that people should not engage in any of these four forms of improper influence over a member of the California legislature and in someone's dealings with those legislators.